Nathan Enos. I'm a senior attorney at Oliva Gibbs here in the OKC division. I want to talk a little about 52 OS section 87.4, which regulates the affidavit of filing polling elections and how they tie to title examination. But first, to get there, we're going to go through a little oil and gas history, why we have pooling, what is pooling, how to properly execute pooling orders, the state's requirements for pooling, so on and so forth. It all starts with the rule of capture, which is a basic property law. Those fellow lawyers, this was first, second day of property. But under the rule of capture, a person acquires ownership of previously unowned or fugitive resource only by reducing it to actual possession or control. Mere pursuit or opportunity to capture it is not enough. First person to extract oil and gas and other minerals gains the ownership. This principle is, with those of us that are in the oil and gas industry, is what we live on. It's a derivative of first come, first serve. It helps progress. It helps people create innovative ways to extract oil and gas, and so on. The rule of capture created a race to drilling. We included some of the old oil rigs that you might have seen in There Will Be Blood and similar movies. The rule of capture created a race to drilling, and as such resulted in over drilling, premature loss of reservoir pressure. Each state responded independently by creating regulatory commissions to prevent waste and protect the correlative rights of all the owners. None of this was more evident than Spindletop in 1902. I've got a few facts about Spindletop. First well was drilled around 1900. Actually, I think it's in the next slide. Yeah, the first well was drilled around 1900 and was just barn burner. This created a race kind of similar to what we saw in the 49 gold rush. Everyone was going out there drilling, created the issue of drainage, which I wanted to tie in this slide from There Will Be Blood, because it actually does have vital importance. Reservoirs were being drained from adjacent lands, and this created massive losses over the coming years. On the third bullet point down here, talking about overabundance, Spindletop wells went from producing over 17 million barrels of oil in 1902 to half of that the following year, kept decreasing and decreasing. The increased demand for legal and regulatory frameworks governing mineral ownership, leasing, conservation, and eventually forced pooling and spacing laws in producing states like Oklahoma set the stage for Oklahoma to become one of the nation's leading oil producing states in the early 20th century. We got a couple historic case law. This is from another state, but it drives home the rule of capture. In Ohio versus Indiana, more detailed. The state of Indiana enacted a statute prohibiting the waste of natural gas by requiring these substances be confined within wells, pipes, or other safe receptacles after being struck, with a maximum allowance of 2 days for escape into the air. Plaintiff, who had possession or control of natural gas, argued that enforcement of the statute constituted a taking of private property without adequate compensation, denial of due process under the 14th Amendment. The Ohio Oil Company drilled a well in Indiana, specifically targeting oil. When the well produced large quantities of natural gas instead, the company allowed it to continually blow into the open air, hoping oil would follow, violating the 1893 conservation statute. The owner essentially saying, look, this gas, has value. What are we doing here? And this went up to the Supreme Court, and this is where the rule of capture got brought over to oil and gas law. Ohio Oil Company had drilled multiple wells into a gas reservoir that supplied nearby towns with a steady supply of natural gas. The state wanted to preserve this reservoir for as long as it could. The holding in this case essentially said, with the nature of gas being as amorphous and moving as it is, the actual possession or control of it you have to have actual possession or control to have ownership. Citing this case, Considering the fact and the peculiar situation of the substances, as well as the nature of the character of the rights of the surface owners, we cannot say the statute, referencing the Indiana statute, amounts to a taking of a private property when it is but a regulation by the state of Indiana of a subject that is especially a subject which especially comes within its lawful authority. Oil and gas ownership does not exist until physically captured. The role of conservation agencies. This is what we in Oklahoma, call the Oklahoma Corporation Commission, or I'll refer to as OCC in upcoming slides. They're created with, they regulate energy. Well, for us, oil and gas, but they cover a lot of different divisions. But their main goal is to prevent waste. Conservation agencies regulate drilling and production, so operators do not unnecessarily deplete reservoir pressure, drill excessive wells, flare vent improperly, or leave recoverable oil and gas underground. This is go back to the previous slide to prevent, another spindle top from happening, for humans to not act like humans and overindulge and ruin it for the remaining group out there. Protect correlative rights, make sure each owner in a common reservoir has a fair opportunity to recover their share of production. And this will tie back into later when we talk about compulsory pooling in Oklahoma and how I think looking at other states, I think we got it right. Sorry if these are a little small. The establishment of the Oklahoma Corporation Commission, established in statehood in 1907 to regulate certain Oklahoma state industries in the best interest of the public. This includes public utilities, transportation, pipeline safety, and oil and gas regulation. Now, the commission was set up to prevent waste of oil and gas resources, protect the rights of the mineral owners, prevent pollution and protect groundwater, and regulate drilling and production operations. Originally established to regulate railroads, public service corporations, and transportation commissions, ensuring fair rates and preventing discriminatory practices. Unlike most states, the OCC is actually a constitutional commission, meaning it has authority directly derives from the Oklahoma Constitution rather solely by legislative enactments. We saw the need pretty early on, actually very early on at the beginning, to set up the OCC. The commission is governed by 3 statewide elected commissioners, each serving a 6-year term. I want to say it was 4, but I think it was 3. Now, what tools, when it comes, this is all pertaining to oil and gas. We're not going to be discussing railroads or transportation or pipeline safety, maybe a little bit of pipeline safety. What tools does the OCC have as far as, you want to drill a well? What do we do? I'll discuss each of these in detail with examples on later slides. We have spacing orders, pooling orders, density orders, increased density orders, location exception allowables, and recently, because we're getting really good at extracting this stuff out of the ground, multi-unit horizontal well orders. Spacing orders establish the size and boundaries of drilling and spacing unit for a common source of supply. Defines the area and acreage comprising the unit. For example, it can be, I have here 40, 160, 640, or 1280, but it could be 10. It could be, I've seen them every acreage imaginable, covering, portions of sections going every which way. Spacing orders identify the common source or sources of supply to the order. What does it cover? What formations? Where are we going? Establishes the permitted well location or tolerance requirements. Where are we placing this well? How many feet from the boundary line can it be? Where should it go? Provides a production for the unit well is shared by the mineral owners within the unit on their prorated ownership, and prevents the drilling of unnecessary wells. All goes back to the original reason why we have the OCC. We don't want to overproduce and lead to another 1902 spindle top. The pooling action, and again, I'll have examples of all these in the later slides. Pooling established to effectively develop oil and gas production when multiple owners have a right to develop the same reservoir but cannot agree on a lease or develop the development plan. I should have said before, there's 2 types of pooling. This pooling refers to compulsory pooling or forced pooling. Not all states have this. Oklahoma, again, I think we got it right. If it's established that it would serve the greater good for this well to be drilled or multiple wells to be drilled and produced, then owners are going to be required to ultimately, if they need be, surrender their rights for the production of oil and gas or any other hydrocarbon. Prevents waste, protect correlative rights, and prevent holdouts from a single owner, or encourage orderly development. I added in here, you don't want your minerals produced, too bad, so sad. This forced pooling prevents a single owner from saying, no, I don't want a well drilled on my land. No, I don't care about royalty checks, so on and so forth. It gets things moving along. Density orders determines how many wells can be drilled within a spacing unit. Earlier on, we were seeing, it's a lot of one wells for every pooling order is one well. There were no subsequent well provisions or very limited subsequent well provisions. And to drill a new well under that same order, you need an increased density order saying, hey, look, maybe one well wasn't enough. We're going to need another one or a couple more. Location regulates where the well can be placed within the unit, including setback requirements. We know where should this well be placed to properly extract the oil gas from the subject common sources of supply. Allowables limits the amount of oil and gas may be produced from a well to prevent waste. Give me maximum daily rate from a well and can produce to prevent waste, protect rights, and balance market demand. And more recently, the multi-unit horizontal well orders. Wells can be spaced and exist over multiple sections of land. It was established in 2011 by the Shell Reservoir Act and later codified. This, again, all ties back to the general duties and obligations of the OCC, prevents waste, protect rights, and aid in future development of oil and gas. I've been practicing oil and gas for, I think, gosh, I'm getting old. Is it 14, 15 years now? And looking at title, you can see how far we've advanced on drilling, like just going from these single vertical, and they still exist, horizontal wells, these massive multi-section laterals that go up and down along the reservoir. It's engineering I'm blown away by it. This is an example of a spacing order. I'm sorry if it appears a little small on your screen, but I pulled this off of the OCC website. It's a little bit older one, 1969. And it was filed by Big Chief Drilling Company, and this establishes a 640-acre drilling unit it includes multiple sections of land. They were going after, let me see here, it's a Hawksbar formation. So we have Hawksbar D, multiple formations here. But I just wanted to provide an example. If you look at this on the second page of it, it lays out all the different spacing orders as they traverse or cover the different sections. And this is just standard example, I think. Nothing really jumped out, but it was something that I thought would be good for reference purposes. Here's an example of an increased density order. If you look at bullet point number 6, and again, this is a more modern one. This is also pulled off the OCC website. If you look at number 6, the relief requested. Now, this is where they're wanting 4 additional wells drilled under the original spacing order. So, like I said before, an increased density could allow, 1, 2, right here we see 4 additional wells. All right, more modern times, multi-unit order. This one targets the Woodford Formation, and applicant is looking to drill multi-unit well. We have covering section 7 and 18, I believe. And right here, it gives on, sorry, right here, no, you can't see my mouse, under 17.5, it targets a measured depth from the first to last perforation. Again, these are 2 640-acre units, but it's going to be 1280, and 2 of them together. And right here, and if you notice the 17.6, the second to last line, it gives a completion intervals, which we're going to discuss in more detail later. But as it ties into ultimately title examination when it comes to rendering division order opinions, the owners of, if a well covers multiple lands, the owners of each section are entitled to their proceeds in the proportion of which the lateral traverses each section. Now, this isn't the case in every state. Other states have multi-unit wells, but if it covers 2 sections, it's 50-50. It doesn't matter if the lateral is 75% in one section, 25 in another. It's 50-50. Again, I think my personal belief, it makes things a little more complicated when it comes to getting PAYDEX ready, but I think that, you know, it goes back to protecting the correlative rights. You know, everyone should be entitled to what they own, and I think, again, Oklahoma's done a very good job at that. I want to back again by saying this, and I'll probably repeat it multiple times. We see through all these orders, statutes, case law, so on and so forth, that Oklahoma is very operator friendly. We welcome drilling. It's a huge part of our a lot of people's everyday life. It's great for the economy. I moved to Oklahoma in 2009, and most people I know are about 1 or 2 degrees of separation from someone that works in the oil and gas industry, if not in it themselves. Multi-unit. In Oklahoma, this is what I mentioned earlier. I should have gone over this slide. In Oklahoma, proceeds from production attributable to a multi-unit horizontal well are allocated among the affected space units based upon the percentage of the completed lateral traversing each unit, as determined by the OCC. It's not the same in every state. Like I said, here we have a 3-section multi-unit lateral. It looks like we have 41%. Looks like the surface location was here in section 10. I'm reading this correctly. And 41% is of the laterals in 9, 42% is in 4, and 17% is in section 33. So following what I said earlier, the owners of from production from this well, owners of section 33 are entitled to 17% collectively. Owners in section 4 are entitled to 42% of production collectively, and owners in section 9 are entitled to 41%. This one's a little tricky because it also covers 10 too, so I can't tell some of that's going in 10. Should have picked a better slide, but this one also did a really good job. One of the reasons I picked it is all these little white, these blue, yellow, all these dots everywhere. Those are wells, just to show how productive we are in a state. You know, we're seeing 1, 2, 3, 4, 5, 6, 7, 8 to anywhere from 2, 5 doesn't really have anything going on, or 32, but we got like 8 to 10 in other different sections. So once we find something, we're pretty good at getting it out. Champlain Refining Company versus Corporation Commission of Oklahoma. I'll pull in some case law here and there. Champlain challenged the constitutionality of Oklahoma's Curtailment Act, the conservation statute, and the proration orders issued by the Corporation Commission. They argued these limits restricted their right to extract oil, to extract and process oil, claiming it's taking of private property and unlawful restriction on interstate commerce. This, let me get to my more detailed notes. This case essentially held, like I said, we're very operator friendly here. This case held for the Corporation Commission that, you know, the commission has authority to regulate, process matters that relate to oil and gas. And here the holding, every person has a right to drill wells on his own land and take from the pools below all the gas and oil that may be able to reduce to possession, including that coming from land belonging to others. But the right to take and thus acquire ownership is subject to the reasonable exertion of power of the state to prevent unnecessary loss, as I mentioned before, destruction or waste, and that power extends to the taker's unreasonable and wasteful use of natural gas pressure available for lifting the oil to the surface, and unreasonable and wasteful depletion of common sources of gas and oil to the injury of others entitled to resort to and take from the same pool. This case validates the state's right to enforce proration laws to prevent economic and physical waste. In Patterson, the plaintiff owned mineral rights on tracts of land where a producing well was located. Pursuant to Oklahoma well, and again, I apologize for the font size of this, it appeared larger on my screen. Pursuant to the Oklahoma Well Spacing Act of 1935, the Oklahoma Corporation Commission created a 10-acre well space unit that combined the plaintiff's tract with the tract of other lessors. Under this order, the plaintiff was required to share production or royalties with the other owners in the unit. The plaintiff sued, alleging that the order unconstitutionally deprived him of his private property and impaired the obligations of pre-existing lease contracts. He claimed a legal right to to all the oil produced exclusively from the well situated on his specific plot. He's essentially saying, hey, look, this well is on my land, so I should be entitled to everything underneath it, absent the spacing order. Doesn't matter that they own, within these 10 acres. This well's on my land, it's all mine. This case upheld the 1935 Well Act, so the owner did not win. And states have broad police power to regulate oil and gas and to prevent waste, conserve natural resources, and protect the correlative rights of all property owners in a common reservoir. Pre-existing lease contracts are entered into subject to a state's regulatory power. You can't contract your way around OCC's power. Doesn't matter what's written in a contract. They ultimately have the authority to regulate. If they decided, these are all done by hearing, all these spacing orders and everything. If they decide that it's a 10-acre spacing unit, that's a 10-acre spacing unit. And everyone within those 10 acres is entitled to a share of production. Like I said before, it upheld the 1935 Well Spacing Act and confirmed the OCC, Oklahoma Corporation Commission, may establish drilling and spacing units. I have a quote from there. It's already been decided that this police power of state to prevent the destruction of the common source of supply may be exercised by regulation of the production therefrom. Again, just driving it home, the state has ultimate authority to space, regulate, and you gotta listen to them. Pooling generally, there's two. I'm going to talk a little bit about voluntary pooling. It still is a viable option in Oklahoma. Like I've said, I've been practicing here to Legal Gives. We cover all aspects of oil and gas. My main experience is in title examination, assignments, conveyances, contract reviews, and so on and so forth. But I've had two clients go the voluntary pooling route. It is still a viable option. Pooling in general, what is pooling? It combines a separately owned interest within a spacing unit, so a unit can be effectively developed. It essentially pools, brings them all together. Together, spacing and pooling ensure their reservoirs developed efficiently, and while giving each owner an opportunity to receive their fair share of production. And like I said before, there are two different types of pooling. There's voluntary or compulsory. Compulsory is forced pooling. When I talk about the OCC pooling, I'm referring to compulsory. I believe these next few slides discuss voluntary pooling, which would be among the lease owners, and this is where pooling clauses and leases come into effect. And also, we'll talk about that when we get to the slide. Who's pooled? Who do you pool? You want to drill a well. You got a bunch of people owning leases. You got a bunch of people owning mineral rights that aren't leased. Who do you pull? You pull those parties who possess the right to drill and develop in the spacing unit, i.e. the executive right owners. This includes unleased mineral owners and working interest owners, otherwise known as lessees. Current working interest owners, I should say, who have not voluntarily agreed to develop the unit. In other words, the party or parties who own the right to operate. The proper respondents to an Oklahoma pooling proceeding are those persons who possess the executive right, otherwise known as the legal right to lease, drill, or otherwise develop the oil and gas estate within the spacing unit. Stated differently, compulsory or forced pooling is directed to owners of uncommitted development rights, including unleased mineral owners, like I said before, lessees holding working interests who have not voluntarily agreed into unit development pursuant to 52 OS 87.1. Stated multiple times just to drive it home, I guess, unleased mineral owners and lessees, parties we got to pull. Now, there's other parties we need to name. We'll get into that later. And this is where it ties into the value of a good title opinion and identifying all the parties who might claim, because curative parties can be quite extensive. Now, the terms of oil and gas lease can have limits on voluntary pooling, and we'll talk about that on the next slide. These are a lot of the clauses. People that are familiar in Oklahoma will say, like 40 acres oil, 640 acres gas, so on and so forth. Those are the limits on voluntary pooling orders. Those have no effect on the Oklahoma Corporation Commission authority to establish spacing orders. I have discussed that a few times with clients, and it can be confusing. Again, next point, the terms of lease cannot affect compulsory pooling. That authority lies solely in the OCC, who cannot be forced pooled. No, not everyone's subject to pooling. minerals owned by certain restricted Indians. They're outside the purview of the state's authority. So they're brought together by a comm or communization agreement. And though there are few companies I know where that specialize in that and very good at it. Once they got it down right, state-owned minerals cannot be force pooled. Unspaced formations, only those formations that have been properly spaced. And this is again referring to compulsory pooling or force pooling. Any unspaced formation. So if you get a spacing order that covers the Woodford, can't pull someone as to the Hawks bar. Doesn't work. Got to get it spaced. And overriding royalty interest owners, that's those people don't own an executive right. They're essentially getting paid out of directly paid out of production. So they don't own, again, going to the first slide, they don't own the present right to drill, so we're not pulling them. I put in a model form 88. This is kind of the standard oil and gas lease that started it all. This one's a very blank, but I zoomed in on a pooling clause right here, and this one doesn't provide acreage limits, but it'll have the right. It gives lessee the right to pool or unitize the lands, and I'm just going to read it out. I have a more modern one, I believe, or if not, any modern lease, they have acreage limitations on it. A lot of times you'll see 160 acres for oil, 640 acres for gas, 40 acres for oil can be pooled, 640 acres for gas. Those are the most common ones that I've seen. What a pooling clause might look like is like this: a lessee shall have the right to pool or unitize the lands covered hereby with other lands, whether or not owned by lessor, so it can be owned by someone else, into spacing unit or units for drilling and operations thereon. Unless he agrees that lessee may pool or unitize said lands covered hereby in any portion thereof with other lands not owned by lessor into any such spacing unit or units in accordance with then existing or any future rules or regulations of the Oklahoma Corporation Commission. So this is allowing, you got at least one that covers the northeast corridor, all the minerals there, at least two that covers the northwest. So guys are like, hey, let's work together. Let's put this all as one. This clause will let them do it, assuming both leases are the same. There's not limitations. In terms of oil and gas lease, now this is a more modern one. You should have, there's copies of the slides that are submitted with this presentation. I invite you to look on it a little bit closer. Bullet point 3 is a more modern pooling clause, and this one covers 160 acres for oil and 640 acres for gas. And yeah, it's just more like the model form 88 was kind of a bit older one, but the lease also, I just want to talk about some other standard terms because the royalty provision will come into in discussion later when we talk about pooling current leasehold owners. So right here I have royalty provision, which provides for 1/5 or 20% of all the oil and gas produced. So that's what is entitled to the lessor or the mineral owner. 20%. Sometimes standard used to be 1/8. You know, a lot of times we've seen 3/16. Pretty much the more often than not, it's 3/16. You know, sometimes you'll see a quarter, 1/5, maybe even a 1/8 still. This again contains a modern voluntary pooling provision, limits the allowable acreage in a voluntary pooled unit. Like I said before, bullet point number 3, they're granted the authority to pool 160 acre unit for production of gas, for oil, sorry, and a 640 acre unit for the production of gas. Again, no effect on the state's authority to establish a drilling and spacing unit. If they don't want, if the leasehold owner, if the operator, whoever wants to drill the well decides, you know, we want to space this at 640 acres and go through the Oklahoma Corporation Commission, this clause has no effect. You cannot contract your way around state's authority. Under the terms of this lease, the mineral owner is entitled to a 1/5 royalty on all production. The lessee is entitled to the remaining 4/5 as of right now, as this is written. Again, there can be subsequently created burdens, such as overriding royalty interest, where they essentially carve out the net revenue interest. So the overriding owners are not paying any of the cost of the well, but they get a share of the proceeds. And assignments of the oil and gas lease. The current owners of this lease would be subject to a forced pooling. If this lease is owned by ABC Corporation and they convey it to DXY Corporation, and then it is decided by a third-party leasehold owner operator that they want to drill this well, ABC Corporation would not be pooled. It would be DXY. It's current owners. Another clause here that has a 90-day cessation of production clause. Just want to shut in. This is fairly standard oil and gas lease that we're seeing modern times. I didn't include any depth limitations or anything like that because those don't really have any bearing on this discussion. Voluntary pooling. This is a contractual method of pooling that combines separately owned interests within a spacing unit by voluntary agreement. Again, this is not involving the Oklahoma Corporation Commission. Usually authorized by a lease pooling clause, like we saw before. Either one of these. This one's way more broad, but this is another example. Lease pooling clause allowing the lessee to combine multiple tracts or leases for unit development. All tracts combined in a unit shall be treated as though they are within the boundaries of the lease. Again, this drives home the same one of the same reasons we established the OCC, even though this is by voluntary agreement. It protects the correlative rights by ensuring each owner receives only their share of production. Commonly done through declaration or designation of pooled unit. You need to file, if you decide to do this, you need to file a declaration of unitization or similar instrument in Oklahoma saying, hey, look, me and this other person, we're pulling these leases together and we decided to create this unit just to provide record notice for the public. And again, like we'll discuss further as this ties into title examination, a lot of the commission side of it, there's not a lot of evidence when it comes to public like examination of the records, the land records. That's why this presentation is Title 52 OS 87.4 that regulates the pooling affidavit filing of elections and how vital it is for marketable title. Declaration of pooling. Declaration of pooling is a document filed by the lessee or operator exercising pooling authority granted in a lease. When the lease contains a pooling clause, the lessee may be allowed to pool the lease tract with other tracts by executing and recording a declaration that identifies the pooled unit, the leases or lands included, the unit size, and the well formation covered. Usually, sometimes they include it'll be to explore rights within the whatever. Let's use Hawks Bar formation again. It's not required, but sometimes it's included. See a lot of these earlier on. Trying to think, there's quite a few in the 1960s that I saw recently. Like I said, I think I have one or two clients that still went the voluntary pooling route, and it is completely viable. It's just not the main method. Forced pooling, compulsory pooling appears to be quicker and cleaner. Unlike a community lease, the declaration usually does not create pooling authority by itself. It implements pooling authority already granted by the contract. Yeah. So declaration is just saying, hey, this is what we decided to do. It's not creating any new authority. Pooling by agreement occurs when separate mineral owners or leasehold tracts are combined voluntarily by contract. This usually happens through a pooling clause, like I said, oil and gas lease, or through separate pooling agreements signed by the affected owners. The key point is that the parties have agreed to treat their separate tracts or interests as one pooled unit for the purposes of drilling, production, and allocation of proceeds. It stops what happened in, I believe it was Indiana, or I forget which one, the Champlain case, where you don't want the well being drilled on Farmer A's land, even though Farmer B is right next door. Farmer B is like, hey, some of those minerals, coming up from my land. This prevents that. It's saying, hey, this well we're assuming covers all these tracts, so production from it is split, so ownership within those tracts. Community leases. Community lease is a single lease executed by multiple mineral owners covering separate tracts of land. Because the owners join in one lease, production from any part of the lease premise is generally treated as production for the benefit of all lessors, unless a lease provides otherwise. In effect, the lease itself can operate like a pooling agreement. These separate tracts are developed under one common lease. Yep, it's just multiple owners executing one lease. They might own in one of them owns in the north half, the northeast quarter, one owns in the northwest. They have a lease to the north half. The whole thing is leased, covers the land. You have your spacing, not spacing, you have your pooling and unionization all right there. Again, this is not very common. We see forced pooling. Sorry, compulsory pooling. Issues with voluntary pooling. This is why what makes forced pooling so great. Holdouts. You could have a party saying, no, I don't. No matter what, I don't want any well drill. No matter what, I don't want anyone extracting the minerals under my land. I'm not going to do it. I'm not getting paid the right amount. You name it. Pick the excuse. So voluntary pooling also creates a holdout problem. Because the operator needs agreement from multiple owners, a single owner may refuse to pool or demand better terms than everyone else. That owner may know their consent is necessary and use that as leverage to extract a higher bonus, larger royalty, or other special concessions. Like I said before, yeah, you could have one person, one apple could spoil, well, not apple, everyone's the right to do what they want with their stuff, but you could have production be held up significantly through the voluntary pooling route. Costs, even if most owners are willing to agree, the cost of locating every party and negotiating separate agreements can delay development or make the project less efficient. This is more evident in areas where title is more complex, where you may have multiple mineral owners. You could have families of deceased, so on and so forth. I mean, I can only imagine if Carter County or McLean County, you can have, 300 mineral owners in a different individual tract, going out and leasing every single one of them, or their heirs, could be quite exhausting. This is not exhausting, but cumbersome. I did a voluntary pooling example. Assume oil and gas company leases 2 20-acre tracts in area where the applicable spacing law requires 40 acres to drill. Standing alone, each 20 acres is not large enough, the acreage requirement. Yeah, it's still a viable option, but it's rare. You can create a 40-acre unit. Compulsory pooling, again, I apologize for these slides. Maybe they're small on my screen because they're split. But compulsory pooling is also known as forced pooling. Created by statute, the process varies significantly from state to state. Generally, an owner with the right to drill and produce within the unit may file an application with appropriate conservation agency to pool the remaining interests. In Oklahoma, any party who owns or may own an executive right to drill develop should be named in a pooling application. So this is the operator, files a pooling order. Who do you name? You name everyone that owns or may own, and that is, we'll come to that later, that is crucial. The main method of pooling used by operators in Oklahoma, this is the main method. Sorry, forced pooling is the main method used by operators in Oklahoma. It's very operator friendly. You have to make a good faith effort. It's formation specific. Formation or formations, selection based. So you have various selections. You have options. Every party who has a present right to drill could either participate in the drilling of a well, so they need to pay their costs, but they could participate in, or they get pooled, which means they get paid a bonus and their interest gets captured essentially underneath the pooling order. It's conservation oriented. It prevents holdouts. It moves things along. It's very, very operator friendly and has been very helpful, I think, in the development of the oil and gas industry in our state. Advantages of compulsory pooling: prevents holdouts from blocking development. Forced pooling allows the units to be developed even when one or more owners refuse to lease, participate, or agree to voluntarily pool. Protects the correlative rights. Promotes efficient development and prevents waste. It helps ensure the spacing unit can be developed as one unit, reducing unnecessary wells. And protects the correlative rights. Each owner is given an opportunity to receive their share of production, either by participating in the well or selecting a bonus or royalty option. This, it moves things along. I can't stress this enough. Preventing the holdouts. You can have, it stops, disgruntled or just trying to be difficult. People use their position as leverage. This moves things along very quickly and cleanly, I might add. The spacing orders are very, very specific in what they cover in Oklahoma. You're not having, various tracts. It's very square shaped and for title examiner's standpoint, easy to follow. Before 1935, oil and gas production was governed largely by the rule of capture. In Oklahoma, we did a little different. In 1935, the Well Spacing Act authorized the OCC to create drilling and spacing units, voluntary pooling was allowed, but holdouts could still frustrate development in the unit. 47, Oklahoma authorized compulsory pooling after notice and hearing. So you got to give these parties notice. You can't just pull them and say, hey, look, this guy owns this. You surrendered your rights. You got to provide proper notice by mailing. Let them know that you're drilling a well there, that you think they own an interest, and here are your options. You can participate, or here are some of these election options. And we'll have an election slide later. In modern times, this is the main tool used by operators, and pooling in the OCC in general has advanced with the development of production methods. Multi-unit, and you can see nothing's more evident than the multi-unit basis. The OCC, even though their website has not been updated with the times, I feel like they move along with the industry very well. Compulsory pooling in Oklahoma is governed by 52 OS 87.1. Once a drilling and spacing unit has been established, the interest within the unit must be pooled before the unit can be developed efficiently. So before you put that drill bit in the ground, you got to properly name your parties, pool them, give them the right to participate. They can either participate or surrender their right by election. If the owners cannot reach a voluntary agreement, an owner with the right to drill may ask OCC to pool the remaining interest. Pooling order then gives each respondent an election: participate in the well or accept one of the bonus and royalty options. This is a case regarding the OCC. The mineral owners of a drilling unit proposed a well and applied a forced pooling order from the OCC. Non-participating separate owners, the appellants, objected to the pooling order. They argued that the commission could not legally force the unit to pool unless the applicant bound themselves unconditionally to drill a well before the pooling. So they're saying pooling orders have a clause in it. Right here. As long as a well is proposed, the commission has authority to pool the interest. The pooling order itself does not inherently mandate the commencement of drilling operations. What the appellant is saying is, you need to guarantee that this well is being drilled before I agree to be pooled or anything like that. And the pooling orders have commencement clause, sometimes 120 days, 180, whatever, where they need to begin the drilling of a well for the order to be good. So the order itself can capture the pooled rights, give them to the operator, the parties elected. And however, you have to condition subsequent, you need to drill this well or commence operations. The commission has authority to force pool a well, to order forced pooling if a well is proposed. And here the appellant offered no evidence the forced pooling statute was unconstitutional as applied. The commission has made a definite position for the payment of costs. Oklahoma pooling, spacing order to pooling election. Spacing order discussed this a little briefly before. The OCC first establishes drilling and spacing unit, identifying the land and common sources of supply to be drained. Pooling application and notice. If no private agreement is reached, a mineral owner may apply to pool interest in the unit and must provide notice to the affected respondents. And we'll get into later what a respondent is. Pooling hearing. A hearing is held before the OCC administrative law judge, where the applicant presents evidence on ownership, notice, good faith negotiations, well costs, and fair market lease values. Pooling order and elections. Finally, final order sets out each respondent's election options, deadlines, and payment obligations, including the choice to participate or accept bonus and royalty options. I believe there's a slide coming up with election options. Oklahoma forced pooling application requirements. There must be unit space. Applicant must possess the right to drill and produce hydrocarbons. Doesn't matter the size of the interest. You can have a 1 acre interest and still file an application to force pool the other 639 acres. The applicant must determine the identity of all owners in the unit as of the day of the filing of the pooling action. This is where a title opinion becomes vital for operators. We want to say not only who owns this, but who is claiming to own it. So because if the party, stress this enough, if a party is not named in a pooling proceeding, pooling in a pooling order, then the pooling order has no effect as to that party. So they're not bound. They're an unleased mineral owner that entitled to their payment of the proceeds for extracting their minerals. The applicant must make a good faith effort to reach an agreement the determination of the fair and reasonable value of the right to explore and produce hydrocarbons from the named common source of supply. An application must include a fair and reasonable mechanism for the respondents to elect whether to participate in the unit development. AMICO, the Corporation Commission. In this case, OCC established a drilling and spacing unit, initially force pulled mineral interest owners for a specific well, one well at first. AMICO and the other parties participated. They paid the drill costs in the initial well. AMICO and the other parties took the risk. You never know what the first well is going to produce. Other parties elected under the order, which means they chose one of the options to receive a royalty and a bonus and surrendered their rights to AMICO. The well was awesome. It sounds like it's productive and profitable. I don't know what that means in those terms, but it sounded like a good well. Subsequently, the non-electing parties, so the parties who were force pulled, sought to force pull a second increased density well within the same drilling and spacing unit. So they let AMICO take the risk in the second well. They're like, hey, I think we want to participate in this. We want to share a bigger share of this. Does the OCC have legal authority to pull by well bore? No, they don't. The answer to that, I should say no. They pull by on a unit-wide basis. And this is like, you don't get a second bite at the apple. You don't get to participate in the first well, or not, sorry. If you participate in the first well, you can elect under second well. You don't get to not participate on first well and then subsequently try to participate in later wells. This comes into effect later on when we're talking about old pooling orders and their effect on new multi-unit, like horizontal drilling. Corporation Commission exceeded statutory authority, allowing a mineral owner to participate in a second well after electing not to participate in the first well. Pooling applies to the spacing unit, not as a unit on a unit basis. Like I said, it's not on a well bore, not on a well by well basis. The owner's initial election allocated the risk and vested property rights in the operator. So they initially said, you're going to take all the risk by participating. If this well loses, I'm not losing anything. But then when it was awesome, a good well, they wanted a bigger share of it. Allowing a later election imposed unreasonable terms on the operator and violate substantive due process. The OCC also exceeded its authority by attempting to effect vested title rights rather than merely interpreting and enforcing its prior order. Court concluded that forcing initial risk capital investors to share the rewards of subsequent increased density wells with those who originally refused to take financial risk was unjust, unreasonable, and a violation of substantive due process. This, like I said, this really comes into effect later when we're talking about old pooling elections and then new poolings under the same formation. Gulfstream versus Layden. Gulfstream Petroleum Corp challenged the district court's authority to evaluate and interfere with the OCC order establishing a drilling and spacing unit. Under 52 section 87.1, the OCC is granted exclusive power to create spacing units and pool interest to prevent waste and protect correlative rights. The OCC has exclusive jurisdiction to adjudicate public rights as they relate to oil, gas, and other minerals. Can't be collaterally attacked by the district court. They're independent, constitutional based. They have ultimate authority. The OCC was established for a reason, including regulation, oil and gas production. That authority cannot be collaterally attacked by a district court. What's in a pooling order? Final pooling order is entered after application, notice, and hearing. Pools the named respondents for the listed lands and common source of supply. Designates the operator and sets the proposed well costs. Gives respondents election options, participate or accept the cash bonus or royalty alternative. Respondents must, within a certain number of days, respondents must elect within a certain number of days. This is set forth in the order. Requires operator to commence operations for the drilling of a well within a certain number of days. Well, what constitutes commencement? Like I said, Oklahoma is very operator friendly, and we found that activities such as staking a well location, surveying, moving equipment on a location, grading, constructing the pad, and other good faith operations have been held sufficient to constitute commencement. As long as they're undertaken with bona fide good effort, you're going to complete drilling. You get all this stuff has to be in good faith. We keep seeing that come up and up. The key is whether the operator has begun operations in good faith with a present intention of completing the well. That's what constitutes commencement. Who should be named as a respondent? We talked about this before. Every person that owns the executive right to drill, develop, any person, any unleased mineral owner, any working interest owner. But then we got curative parties. Curative parties are people who don't own a present right, but are claiming to or may own, or title is unclear as to whether they own, or they just you can keep seeing the same party popping up, but you don't know where they received who granted them their interest. What if the owner of executive rights was not named in a pooling order? Like I said before, this order would have no effect as to that party. Unleased mineral owner. That is not good. This is where title examination is vital. This is where if you want to name those curative parties, because if they actually do own an interest, then they're already covered, they're already named. You want to cover all your bases. What constitutes a curative party? I've written down here, a curative party is a person or entity that is named in a pooling application because of a title defect or uncertainty must be cured before the operator can confidently determine who owns the executive right or working interest. The we are not sure parties. Examples. This is examples of curative party. Let's say we have someone that received their interest in 1919. They're probably not alive. So unknown heirs of a deceased mineral owner. This is where, let's say it was Sally Mae received her interest in 1909. You would list Sally Mae and the unknown heirs, successors, or assigns of Sally Mae. This covers any party that might be, grandchild, great grandchild, so on and so forth. Devising under an unprobated will. Heirs when no probate or affidavit of heirship exists. Parties to ambiguous deeds. Persons claiming under unleased reservation. Record owners where conflicting conveyances exist, dissolved corporations whose successors are uncertain, and trusts or trustees where title is unclear. These are just examples. This list is not exhaustive. They can be, I've found in my over a decade of practicing, it is better to over include than under include. And some of these areas in Oklahoma, we have curative lists that go into the hundreds, and it's better to have that than have an unleased mineral owner within your operations. Most, like I said, list of curative respondents can be quite extensive, and curative parties are often determined by title opinion. And a fact pattern here. I'm just going to read off real quick. This is, kind of a law school one. In 1984, ABC Gas Corporation acquired a 1/2 interest in the Northeast quarter of Section 10, Township 5 North, Range 8 West, Canadian County. It's called Blackacre. In 1992, the record reflects that ABC Gas LLC executed a mineral deed purporting to convey an undivided 1/2 interest in Blackacre to Mary Sue Smith. The record contains no documentation establishing the ABC Corporation ever converted into, merged with, or signed its assets to ABC Gas LLC. Mary Sue Smith later died. No probate proceedings have been filed in Oklahoma or any other jurisdiction, and no affidavit of heirship appears of record. 2008, James Smith identified himself as the widower of Mary Sue Smith, executed a mineral deed conveying an 1/2 mineral interest to Blackacre to John Dean, trustee of the 1985 Jimmy Dean Living Trust. The deed contains no explanation of James Smith's authority to convey Mary Sue's interest. Several years later, Loretta Dean, acting as the trustee of the 1985 Jimmy Dean Revocable Trust, executed a mineral deed conveying the same undivided 1/2 interest to John Smith. However, the record contains no instrument establishing that the 1985 Jimmy Dean Living Trust and the 1985 Jimmy Dean Revocable Trust are the same trust. That Loretta succeeded John Dean as trustee, or that the trust itself ever acquired title. John Smith now appears to be the record owner of the mineral interest, the operator's application to pool the Mississippi and Common Sources supply. Who should we name as respondents in this pooling application? My answer, pretty much everyone. A pure prudent title examiner will conclude that John Smith is most likely owned the executive rights. This is all assuming this is unleased. Again, I should have said this is the unleased mineral interest. So there was no prior lease. It was held by production from an old well. This is all unleased. John Smith is the person who most likely owned the executive rights and should therefore be named as ownership respondent. However, the chain contains multiple unresolved defects. The following party should be named as curative respondents to ensure the only person potentially possessing the executive right receives notice of the pooling proceeding. You got to give them notice. If we're naming ABC Gas Corp, ABC Gas LLC, Mary Sue Smith deceased. We got a missing probate. The heirs of Mary Sue Smith, again, missing probate. James Smith, unclear how he received his interest. John Dean, trustee of the Jimmy Dean Living Trust. Successors of John Dean, trustees of the Jimmy Dean Living Trust. And then we got Loretta and the successors of Loretta the Trust. Better, like I said before, it's better safe than sorry. Good title opinion allows the operator to name all the necessary parties to cover their bases. This is just, I'll let you guys zoom in on this, but this is just an example of a random respondent list I pulled off of OCC. So we got 71. We have 71 response on the East half. Here's another one, 57. And this is honestly pretty light. But I just want to give multiple examples. Like these lists can go into the hundreds. Okay, what is an election? What does a polling order look like? Here we got our election options. You know, like I said, you can either participate or elect to have your interest pooled and receive a cash bonus and a royalty. So here, estimated completed well costs, you know, that would be you'd have to pay your share of that. Or options B and C, you get $250 per cash acre. So if you own 2 net mineral acres, you get $500 and a 1/8 royalty. So it's like you're getting leased, but it's only good as to the pooled and spaced formations. Or option C, $200 per acre and a 3/16 royalty. So a little less cash up front, a little more royalty if the well does well. This I did not include on it, but there's always time you have to elect. You have to elect within a certain amount of time. And if you don't, you are going to be deemed elected. And I'm willing to bet that the deemed election is B, 1/8. That's pretty standard. 20 days. And that was for vertical well. Here's election options. It's the same thing for a horizontal well. Again, complete as a dry hole, NA. Completed well. If you look at the well cost, it's a little different. So I should have noted that this horizontal well costs are 458,000 roughly, and these horizontal ones are I think we got 13 million. So a little different, but same concept, same principles. In lieu of part, this provides participation as one option, and then 3 different ones. When you look at the prior slide, we have 2 election options in addition to participating. This one has 3 election options in addition to participating. $2,000 per acre and a 1/8 in lieu of participation. And these are only, like I said, these are only good as the common sources of supply that are spaced. $1,500 per acre and 16.5% royalty, and $1,000 per acre and 3/16 royalty. Why pooling elections matter. Elections give mineral owners and working interest owners the opportunity to choose whether to participate in a unit development. Party elects not to participate, they must choose one of the stated elections. If no election is made within the stated time frame, the owner will be deemed to have elected. This surrenders rights as the right to the same as an election. Only owners who elect to participate in the initial development of the unit preserve the right to participate in future development. This is crucial. You're bound by your original election. There is a deferred election option in OCC which delays a mineral owner's deadline to choose whether to participate or take a royalty. But when you make that election, it's good as a subsequent production. Pooling elections may become increasingly important because prior elections may determine whether an owner has a right to participate in later horizontal well. For example, here I want to do this hypothetical. Okay, let's do one more fact pattern. The OCC created SKZ versus Petty. The OCC created 640-acre joint spacing unit in Caddo County, including the marshland, 13 comments from marshland, Towner Petroleum. Predecessors to SKZ filed an application to pool interest in the leasehold owner, resulting in 2 different orders. The leasehold owners were given option to participate in the development of the unit by sharing the costs and bonus and or override. Appellees elected not to participate in the initial well, the Stevens, and instead accepted bonus or royalties. So they elected under one of the other options. After successful completion of the Stevens, Towner applied for and received permission to drill 3 increased density wells, similar to what we saw before. The appellees later sought to participate in the increased density wells, leading to the issuance of 3 different orders, which allowed the participation despite their earlier election not to participate. Whether the Oklahoma Corporation Commission has the authority to drill, statutory authority to force pool by well bore instead of by the drilling and spacing unit. You get a second bite at the apple. The OCC erred by issuing pooling orders allowing the owners who previously accepted bonuses in lieu of participation to participate in subsequent wells. So once you elect under that first election and you elect not to participate, you're bound by that election on subsequent wells. Important amendments, 52 OS 87.1. In 2007, the statute was amended, including various changes, most importantly, the addition of subsection 87.1G. This deals with horizontal units. I'm not going to read these all verbatim. The one that I want to drive home is 87.H3. These all tie together in unison, but this is regarding like elections under a horizontal unit. But it says, as any such well which is subject to this pooling order, which was entered prior to the effective date of this act, in order to be entitled to the rights of this subsection, the owner must be vested with the right to participate in the subject well. Problem with this is, if let's say you have a new multi-unit section that covers the Woodford Formation, and there was an 80-acre unit that also from like, let's say the 1980s that covers the Woodford, and party A elected under option B for a 1/8 royalty and did not elect to participate, as long as that well is still producing and that drilling spacing unit is still in effect, that owner is bound by that election. They don't get a second bite at the apple. They are bound by. That's why you see a lot of these operators receiving the old production or old pooled interest from prior operators. And record title is very silent. I'm going to say very silent as to the elections of the parties. So if these parties are bound by their prior elections, what is the title examiner supposed to do? How do they know these elections? There's one thing, and it's we'll talk after this, but it's 87.4, which discusses the pooling affidavit. The owner must have been vested with the right to participate in the subject well as of the effective date of this act. As stated prior, forced pooling in Oklahoma is done on a unit-wide basis rather than a wellbore basis. Party A elected not to participate under an old pooling order. Those rights were surrendered as to the new pooling order. Is this constitutional? I mean, it's not what they agreed on. It's definitely not. If you have an owner that, they're drilling this well in an 80-acre tract, and granted the election is only sufficient as to those 80 acres, but that's a different animal than saying, we're drilling a 640 well. This is retroactive application too. This appears it's different. It's applying to old pooling orders. It even says in the first slide, prior to the effective date of this act. And usually laws are not retroactive. Argument: an election under a pooling order, this is what I said before, covering an 80-acre drilling and space unit is not the same as election under a new pooling order covering a 640-acre unit. Is this a second bite at the apple? I mean, I don't know where I stand on this. I think that, parties should be bound by their original elections, but to say you're surrendered your rights as to subsequent production, regardless of the spacing of a well, if it overlaps, who knows? But what I'm getting at is the affidavit now. So this affidavit, like we said, parties have to elect, but those elections are not public record. They're often by letter, by mail, sometimes by email. I mean, who knows? So when a title examiner is examining the record, how do we know what these parties elected under these orders? Because they could have very well surrendered their right to drill. And as to the spaced formations, how are we supposed to know this? Well, this is where the affidavit comes into effect. And it's affidavit evidencing any election for the drilling and spacing unit under a pooling order. And it sets out, I'll give you an example. I'm not going to go through all this, but the affidavit shall set out the names, addresses, and election of the deemed election of each party respondent, including the affidavit shall have a copy of the pooling order attached. So essentially an affidavit on the front says, these are all the respondents. This is what they elected. And then the affidavit may be filed by the operator designated in the pooling order by any other interested party with knowledge of the election made. And this is filed and indexed and recorded against the land where the well is spaced and pooled. So if the well covers, I'm making this up, section 2, township 2 north, range 2 west of Carter County, affidavit of elections is supposed to be recorded and indexed against section 2, township 2 north, 2 west, Carter County. However, this is not often filed. We appreciate it when operators do it. I can just say that right now. Because if not, you're playing a guessing game. Without these affidavits, we have no idea what the elections are, absent contacting the operators, or sometimes those operators acquired a prior entity or company. They have to reach out and pull in their records. It's rarely filed with the county clerk's office. The purpose is to provide public notice of elections under pooling order, but there's no penalty for not filing. So there's no teeth to it. So it says shall and you're supposed to, but it's almost discretionary. We're seeing a lot of the more active entity operators doing these, and it's very appreciated. And I think it's necessary to be able to provide marketable title. Here's an example of an affidavit of election. Like I discussed this before. What does it do? Where do you find it? It should be filed in the records, indexed against the land where the well is spaced and pooled. Who should it include? It's all the respondents. So if you can zoom, I don't know if you can zoom in on here, but it says right here, the following elected under paragraph 17.1. So that means that these three parties elected to participate, and these parties elected or deemed to have elected and receive a 1/8 royalty right here. And up top, it names the pooling order, it names the formations it covers. So we know this covers the Mississippi and Woodford, Hunton, and Sylvan, and all of section 12, 8 North, 11 West, Hughes County. So this is just a good example, I think, of affidavit election. Pooling orders and title issues. Sorry, and title examination. The OCC records are separate records and not kept with the county clerk's office. And in addition to that, the OCC is not very user-friendly. It's very tough to maneuver. So there's a lot of other websites that title examiners use, such as Pangea or stuff like that. Title opinions are a crucial step when determining which party should be named in a pooling. Unleased mineral owners, working interest owners, and parties for curative measures should all be named in a pooling. Subsequent operations as to the same formation or formations. What do you do if you don't have the original elections? If you don't have a pooling elections or an affidavit of elections filed, a lot of times you have to rely on the actions of the parties and make a comment as, we assume that this interest has been validly pooled. New horizontal drilling and spacing units overlap traditional vertical wells covering the same formations, the same tracks. Who owns the operative rights? How would you know without an affidavit of election? Like we saw on the one in the slide before, this affidavit of election clearly states who participated. So we know Cortera and Kaiser Francis and 6S Energy all own some, but how do we know who? Without that, how would we know? I have a note in here to put a verbal example, which I did. Current owners are bound by the election of the prior owner. How do you know the election of the prior owner without affidavit of election or the physical election letters? You don't. And the acquisition of interest under a pooling order. If a party is assigned pooled interest, how do you determine which interests are pooled? How can a title examiner determine the elections of an owner under a prior pooling order? Is title marketable? Affidavit of elections are rarely filed, almost appear to be discretionary. 57 OS 87.4 more than an affidavit. It can be a title examiner's lifeline. It designates elections so a title examiner can properly reflect the interests of the parties. This is an example of an assignment of pooled interest. And again, it doesn't require, while this would assign any interests that were pooled under the order, it doesn't discuss which party was pooled under which election, who participated. So it's very broad and unable to determine the elections, merely conveys all vast owners' interests under pooling order 702345. What were the elections of the parties? Who were the parties? If record title does not contain affidavit of election, how does a title examiner determine which these interests are pooled and which elected to participate? What if the formation of the order also included a new pooling order covered by a separate drilling and spacing unit? Without an affidavit, who do you pull? Just name is curative? That's a question I'm looking for the answer for. A little hypothetical here. It's kind of what I've been talking about. Vertical well drilled in section 12 at the time. The section was divided into several owners, including our baby owners A through G. Pooling order gave each owner following options: 1/8 or 3/16. A, B, C elect to participate. D and E elect the first option, and F and G elect the second option. No affidavit is filed. The well produces. Now, 10 years later, new horizontal wells proposed and drilling spacing that overlaps older vertical unit. A, B, and C are going to have the option to participate in the new well. D and F are bound by their elections in old pooling order. When there's no affidavit of election, it's nearly impossible for a title examiner to determine the ownership of title to the election rights. Even if information is provided, what if elections are not the same? What if Party D carved out an override interest under the prior pooling order? How is that reflected under the new elections? What if the royalties aren't the same? Like, what if there's a lot of what ifs? Final questions. When is an old election binding on a new pooling order? How should a title examiner treat an interest when no affidavit election has been recorded pursuant to 52 OS 87.4? What do? Do we guess? We put curative comments. You got to look at the actions of the parties. I think that's what you rely on absent direct information. Does a prior election under a pooling order operate as a surrender of owner's executive rights in the pooled formation or formations? Do those rights remain with the owner absent subsequent conveyance? What if an owner elected to participate in initial well, but elected not to participate in a subsequent well under a prior pooling? Does a second election, do they relinquish their rights, or does a party have a right to participate under a subsequent pooling order? So they elected under well A, but well B, they're like, maybe they didn't have enough cash on hand. Who knows? They were pooled under well B. Now are their rights surrendered? These are just things to think of. So I appreciate it. Again, my name is Nathan Enos. If you ever want to reach out or contact me, I'll go to the top of my slide. I think you should have a copy of this too. I'm senior attorney here at Aliba Gibbs in the OKC division. Again, I appreciate your time. Thank you.